If you're worried your company might end up in insolvency, you're probably worried that you'll never be able to be a director of a company again. But here is something you must clearly know. Insolvency does not automatically stop you from being a director again in the future. There are thousands of UK directors every year that put their business through an insolvency process, and many of them have the exact same fear that you have right now, and it's, will an insolvency permanently damage my reputation? Could you end up being disqualified as a director for years and years? And does an insolvency prevent you from running another business in the future? Now, if you clearly understand this, in most cases, you can absolutely be a director again safely and legally, providing you know exactly what steps to follow. Now, in this guide, I'm going to clearly explain what UK law says about being a director again after an insolvency, what director disqualification means and exactly how to avoid it, and practical clear steps you can follow to legally become a director again. It's Chris Worden, I'm from Director First. I've helped thousands of UK directors through insolvency and guided them clearly on how to safely become directors again. I have seen firsthand the fears and confusion directors get after speaking to people and searching on the internet, but I've also helped like countless people successfully restart their businesses. And some don't restart the business, but they go on to start another business and they've thrived. So if you're worried or you're uncertain right now, stick with me, because knowing exactly what you can and what you can't do clearly after insolvency can literally protect your future. So let's start clearly by explaining what UK insolvency law says about becoming a director again after insolvency. And here's the clear, simple truth. Insolvency itself does not automatically prevent you from being a company director again. The law clearly allows directors whose businesses have entered an insolvency process to be appointed as directors again in the future, as long as no disqualifications occurred. But here's the thing that you really need to understand. A director disqualification, if you get hit with one, it means that you cannot be a director again for the period that you're disqualified. And you get disqualified for things like misconduct, wrongful trading. You know, if you behaved inappropriately as a director, you're legally prevented from being a director again for a set period if you get that disqualification. But it's not automatic. Like simply going through an insolvency does not trigger disqualifications automatically. Transparency is just required. Like if you are going to be a director again, maybe your new company will want transparent disclosure of any previous insolvency if you're asked. Banks might ask whether you've been part of an insolvency. Certain professional bodies will, your insurance companies will. But I want to debunk some common myths that directors have around this. And the first thing is insolvency automatically disqualifies me forever. Clearly, it's false. It's nonsense. It doesn't. Another one I hear is I must wait a certain amount of years before I become a director again. And again, this is nonsense. It's false. If you're not disqualified, you can become a director again immediately. You can be a director of as many companies as you want, as long as you keep up with the fiduciary duties that's expected of you as a director. Another one is an insolvency is going to damage my reputation. But listen, that's false. Like if you handle an insolvency transparently and responsibly, in most cases you can safely and legally protect your reputation. Now, you've got to understand the law and these myths. If you understand this, it can remove unnecessary fear and confusion about your future. Now, the big worry is disqualification. Okay, now, directors do get disqualified on the back of insolvencies, but let's clearly define what it means. A director disqualification is a formal legal action taken to prevent an individual from acting as a director of a UK company for a specified time. And it typically only happens when a director has clearly breached insolvency laws or acts irresponsibly pre the company going into insolvency. So it could be wrongful trading, fraudulent trading, serious financial misconduct, nicking company assets, ripping customers off. Now, you've got to understand disqualification is definitely not automatic. Just because you put a company through insolvency, it happens in the worst cases. I would say 99% of directors, don't hold me to this, but it's a high number, will be able to be a director again. There was one thing that I did forget to mention. There's a lot of disqualifications happening right now around bounce back loans and around COVID fraud. So if you're one of those people that have took a bounce back loan, you shouldn't have took one, you spent it on stuff that you shouldn't have spent it on, and you go through an insolvency process, or even if you don't, because the insolvency service are clamping down on this now, that's where you could be disqualified, okay? Now, when a director does get disqualified, you're going to get disqualified for a period of time. And the way that it comes about is a disqualification occurs when an insolvency practitioner, okay, has reviewed your conduct, or the official receiver, and they found some serious issues. Now, one of the things you can be disqualified for is, again, bounce back loan fraud. If you've took a bounce back loan and you weren't entitled to take a bounce back loan, or you inflated your turnover vastly, remember you could only take 25% of the turnover in 2019, capped at 50 grand, or if you've spent the money unlawfully. So a lot of people spent bounce back loans personally. Now there's a difference between drawing your bounce back loan down on a Monday and then spending it over 2 years personally to keep the lights on, pay the bills. That's different to taking it on a Monday and transferring it to another account on a Tuesday, okay? Another reason why you might get disqualified is preference payments, and which where you unfairly repay certain creditors over others before an insolvency process. Another area that you can be disqualified is misusing company funds, and essentially, I don't know, taking all the company funds, racking up huge HMRC arrears, and you've benefited personally. Now, that is where an insolvency practitioner, they've got to thoroughly investigate your conduct. That's what they're there for, and they're going to report their findings to the insolvency service, and the insolvency service may take action against you. But if there's no clear misconduct, disqualification just doesn't occur. Now, if you are facing a disqualification, this is what you need to know. You will be disqualified from between 2 years to 15 years, depending on the severity of the conduct. And while you're disqualified, you cannot act as a director or manage any limited company during that period. And if you break these rules, like if you act as a shadow director, so you've got someone who's on the company's house, but you've got access to the bank accounts, you're making all the decisions, that can lead to some serious legal penalties and in the worst cases, criminal charges. Now, I want you to remember, most directors do not face disqualification proceedings after an insolvency. If you've acted transparently, responsibly, and you've worked within the UK insolvency laws, you remain fully eligible to become a director again, okay? Now, obviously, as a director, if you're thinking that you might end up in insolvency, you want to avoid disqualification. And here are the things that I want to talk to you about to limit the chances of being disqualified. And the first thing is you've got to act quickly and responsibly the moment you realise your company's insolvent. Now, remember, all insolvency is I can't pay my debts when they fall due, my liabilities are more than my assets, or someone has taken legal action against you. The minute that happens, really, and I'm going to add this caveat, the minute that happens and you don't believe in your heart of hearts you're going to get past this, you're not going to get on the road to recovery, you've got to get professional advice, okay? And an insolvency professional will clearly guide you on exactly what your options are. And remember, we get hundreds of inquiries a month. We don't do hundreds of insolvencies, okay? Most of our calls are just some really good advisory. You tell us what's going on, you tell us what your worries are, we ask you where you want to get to, we're going to ask for some questions, we might ask for some information from you, and we will show you how to get from A to B legally. And most of the time that doesn't involve insolvency, okay? One of the things that you want to be doing is communicating with creditors, okay? Open, honest dialogue reduces problems from creditors. So even if you can't pay them, tell them you can't pay them, right? Show that you're acting responsibly and show them that you're taking immediate action, okay? Now, this is an important one. Your second clear step here is you want to avoid accusations of trading insolvently, okay? And all that means is you've become insolvent and you've continued to trade, racking up further debts, okay, with no hope of paying those creditors back. So racking up bills at the suppliers, racking up HMRC arrears much longer after you've become insolvent. Now, you should not keep racking up debts if you know there's no hope of recovery, okay? Another thing where you might get disqualified is misusing your company assets. So if you've got company assets and you want to move them out of the company because you've become insolvent in that business and you want to sell them to a connected party, that's fine as long as the connected party pays a market value for the assets. And in that circumstance, you can even get time to pay it. But don't try and sell assets for cheap. Don't try hiding assets and moving them elsewhere. You will get caught out. Another step I want to talk to you about is to maintain accurate records. Okay, dead important this. You want to be getting your returns up to date. You want to get your filing up to date. You want to make sure your accounts are going in on time. You want some management information. Management information on a monthly basis will help you make better decisions in your business. But let's say you're down the line a little bit. You feel like the business may enter into insolvency at some stage in the future. And you speak to someone like me. And we have a chat. I'll give you an example. I've got a builder, construction company, vastly insolvent right now. He has had a bad debt that hasn't paid him. And rightly or wrongly, that has put a huge hole in his cash flow and he can't pay HMRC. Now, he is insolvent on a cash flow basis. He can't pay his debts when they fall due. He's also insolvent on a balance sheet basis because all his assets are not worth more than what his liabilities are. When he spoke to me, they are almost nailed on to win a multi-million-pound contract, and they find out about it at the end of July. And I've said to him, what you need to do is, there was 3 of us on the call, you two email each other and copy me in and say, listen, we have spoken to Chris, and on the basis that this contract could get us right out of the muck, obviously worded better, we're going to continue to trade for the next couple of months. But what they have stopped doing is they've stopped taking personal drawings from the business, and they are making sure that their suppliers are paid on 30 days. So whenever a bill comes in, they pay it, because they need to pay those suppliers to make sure stock is still delivered to site so they can bring money in for creditors, okay? You've got to clearly document every business decision once insolvency has been identified, okay? So, accurate record keeping significantly reduces risk of being accused of misconduct, and that again that protects you from any type of disqualification proceeding in most of the times. So, what I want to talk to you about now is, what do you do next? If you are starting a new company, you want to have learned the lessons from the old company. It's really, really important. It's okay to fail in business, okay? The insolvency laws are there to protect you, they're there to protect creditors. But if you are going to start a new company, you've got to really understand what went wrong in the old company. You know, do a post-mortem. What is it that went wrong? I mean, some things are easy to call. You didn't get paid a massive bill. Well, what you're going to learn in the new company is your credit control going to be tighter. But if it's due to mismanagement and being naive, you've got to learn these lessons, okay? Now, another thing, if you're starting again, you're going to set up a new company, you need to be careful what name you call that new company, because there's a thing called Section 216. And it's the use of a prohibited name. So if you liquidate a business, you cannot use the name of that business or a similar name for a 5-year period, okay? Now there are 3 ways that you can sort of get over this. One of them is you already have a company name that's set up that's similar. So for instance, there's Chris Worden Building Limited, but I've had Chris Worden Building and Roofing Limited, and that Chris Worden Building and Roofing Limited has been trading for over 12 months, okay? In that scenario, you can still use the name Chris Worden. Now, if that business had just been set up, Chris Worden Building and Roofing Limited, it had been incorporated, but it hadn't been trading, it still doesn't count, okay? You've still got a problem with a prohibited name. You can also apply to court to tell a judge why this new name is not in contravention to section 216. That's probably going to cost you about 5 to 8 grand in legal fees. And the best way to deal with this is if you buy the name off the liquidator, okay? Your brand name does not have a great deal of value to anyone else other than you. So a liquidator will probably sell it to you for about £500 plus VAT on the day of liquidation. And then what you'll need to do, you will need to advertise that fact in something called the London Gazette. It'll cost you 180 quid. And then you'll need to write to the creditors of the company to let them know that you've bought the company name, okay? So, listen, I hope you've found this video useful. If you want any more advice, if you want a question answered, drop it in the comment section below. I'll respond to it personally. My name's Chris Worden, Director First. Thanks for your time.